Hello and welcome to this overview of the current state of data protection in Europe. My name is Rosemary Jay and I'm a senior attorney with Hunton and Williams in London.
And my name's Anita Bapat and I'm an associate in the team at Hunton and Williams.
And we are both data protection specialists and part of Hunton and Williams privacy practice in London, which is one unit of our firm's global data protection and privacy practice. Data protection continues to be a very fast developing area of law. So during this session I am going to look briefly at some changes to the international scene, international instruments, and then review recent case law from the Court of Justice of the European Union on data protection matters.
And I'm going to look at the update coming from Europe on the new draft regulation, as well as criticisms of the safe harbour framework as a mechanism for data transfers to the USA. And finally, I'm going to look at a brief summary of recent case law at a member state level.
Thank you very much, Anita. As viewers will no doubt be aware, there are 4 international organisations that have developed standards in the area of data protection. They are the Council of Europe, the OECD, the APEC, that's the Asia Pacific Economic Cooperation, and last but not least, of course, the European Union. We are recording this on European Data Protection Day, the 28th of January. So I'll start by saying something about the treaty which was launched on this day 33 years ago, the Convention for the Protection of Individuals with regard to automatic processing of personal data, the Council of Europe Convention. That convention set out what are still basic core principles for data protection, and they have remained at the heart of developing data protection standards ever since then. But over those 33 years we've seen a gradual development as these are fleshed out in response to the needs to protect data as processing personal data becomes more and more central to our economy and our lives. And this process remains dynamic, as you'll see from the developments we're going to cover. So just to refresh on those core standards in Convention Treaty 108, they look at legitimacy of data processing and transparency, the importance of data quality, controls on sensitive data, things like information about medical details or health, sex life or race, the importance of data security, and individual rights of access for people to see their own data and have other remedies, and of course cover areas such as some exceptions, sanctions, and the need for remedies. Although we now within Europe have a data protection directive, the Convention remains important. Its influence extends outside the borders of the EU because it is an open convention. It can be signed up to acceded to by countries that are not part of the Council of Europe. Signatory states must have laws which meet the standards required in the convention. The convention has been treated as something of a living instrument, I suppose. It's been updated in 2012 to include requirements for independent authorities to oversee data protection and to include safeguards in relation to trans-border data flows. And we can see this element of development in data protection law also in another of the international instruments, and that is the OECD Guidelines. In July last year, 2013, the OECD adopted a revised recommendation concerning guidelines governing the protection of privacy and trans-border flows of personal data, the Privacy Guidelines. And this is the first revision since these guidelines were formulated in 1980. The guidelines are another important international instrument. They have global reach because the scope of the OECD goes much wider than Europe. The guidelines again contain basic principles which apply to personal data and reflect the standards in Convention 108, Treaty 108. The basic principles being collection limitation, data quality, purpose specification, use limitation, security standards, openness, individual participation, and accountability. And the updating of the guidelines has introduced some newer concepts, and in particular we should mention first the requirement for data controllers to have in place a data management practice programme which meets appropriate standards. And this is part of a bigger move towards accountability. Such a programme should be able to let the organisation demonstrate its privacy management programme if required, for example to a supervisory body. And the second one to pick out is breach notification. The obligation to notify data protection authorities of serious breaches of security, and where a breach would adversely affect data subjects, to notify those data subjects. And as we will see from Anita's section later, these are themes that are also reflected in the work going on now at EU level. So, turning then to the case law. In the last 6 months, we have seen 3 decisions from the Court of Justice of the European Union on data protection. This is interesting because over the years since 1995, when the directive was adopted, there have been relatively few data protection cases. Of course, cases are going through the national courts all the time, but they generally only have national impact, whereas cases from the CJEU have a European-wide applicability. And as ever with case law, when you first look at them, they can seem a bit technical, but if we look at the underlying issues, we can see the bigger themes. So, first, case C29112, judgment was delivered in October 2013. The case is called Michael Schwartz and Stad Bochum. And the CJEU in that case considered the relatively new addition of data protection as a fundamental right in the European Charter of Fundamental Rights. And as you will be aware, when the Lisbon Treaty was entered into, the Charter of Rights became part of European law, and it now includes, in addition to the right to respect for private and family life, which reflects the existing right in the European Convention of Human Rights, a specific right to data protection. And really, the impact of data protection as a fundamental right, and quite what that means in practice, is still being explored. We're at very early stages, but at least we can say it won't stop the state taking your fingerprints for a passport, because that is what Mr. Schwartz, in this case, objected to. And he objected to having his fingerprints taken on various grounds, amongst them that it was an infringement of his fundamental right to data protection. The court, in fact, accepted that this was a breach of his data protection right, but data protection is not an absolute right. It may have to give way to other pressing social needs and other requirements. So what the court looked at was this infringement justifiable and proportionate? And the court said yes, it was. It was conducted on an appropriate legal basis. There is a European regulation requiring fingerprints for biometric passports. It was for a legitimate use, the prevention of fraud in the use of passports. And the infringement was proportionate. It was reasonable. It was necessary in all the circumstances. They looked at the fact that this data can only be used for restricted purposes, and moreover, this data is not stored in a central database. It's only on the passport itself. So the interesting thing is that looking at this fundamental right and how it's applied, the court stressed the importance of the tests of legitimacy and proportionality where there is going to be an infringement. Now, in the next case, judgment delivered in November 2013, this is case 473/12, and it's the Institute of Estate Agents of Belgium and Engelbert and Francourt. The CJEU looked at a harmonisation point. As we've already said, data protection laws are based on a European directive, applicable throughout Europe, but implemented by national law. And as the court has recognised, this can produce different approaches in different states. So while on the one hand the court has held, in the case of Lindquist, that the aim of the directive is to achieve effective harmonisation, it has also recognised, in other cases such as Huber, that there will be differences between member states' laws because there is some scope within the directive for member states to take different approaches. In the words of the court in this judgment, some provisions of the directive are necessarily relatively general, given that it has to be applied to a large number of different situations, and that the directive includes rules with a degree of flexibility and in many instances leaves to member states the task of deciding the detail or choosing the options. And this element of flexibility is one of the drivers for the work currently happening on the regulation. And just briefly on the facts of this case, the court was asked whether the directive required Belgian law to include exemptions for a particular circumstance. It's just the facts are interesting. In the particular case, the information was collected, the information in question had been collected on behalf of a regulatory body which supervises the work of estate agents. And they had utilised private detectives to collect this information. Now, one of the requirements under data protection, of course, is transparency, notice. People should be told what will happen to the data about them. There is a problem for private detectives, the private detectives in question, and one assumes all private detectives, being that it's difficult to obtain undercover information when you have to tell people who you are, what you want the information for, and what you're going to do with it. And of course, unless there is a data protection exemption, that is what you have to do. Now, there's a provision in the European Directive that allows member states in their implementing law to provide for an exemption where it is necessary to deal with breaches of ethics by those in regulated professions. In Belgium, being a estate agent is a regulated profession, and the investigation here was into breaches of the code governing them. So it could have fallen within a legitimate exception under the directive. However, in the Belgian law implementing the directive, such an exemption does not apply. The information was collected in a covert manner, so it appears from the case, and it appears that the evidence which had been collected was being attacked because it was found in breach of data protection. The court was asked, in effect, whether Belgium should have brought in such an exemption because there is a provision for it in the directive. And the court looked at the provision in the directive, in the relevant article, Article 13, and held that it was not mandatory on member states to bring in such an exemption. It is up to member states, so there could be different provisions in different jurisdictions, and that element of flexibility and choice under the directive is emphasised by the result of this case. So moving on just to our next one. This is a particularly interesting one around what counts as personal data. If it's personal data, it's covered by data protection law, but that is always a difficult question. The cases, there are two joint cases, C141/12 and C372/12. Judgment was delivered in December 2013, and the case is the Netherlands Ministry for Immigration against unnamed defendants. The applicants in this case were third country nationals. In other words, they were not EEA nationals, and they had applied for leave to stay in the Netherlands and had been refused. They were bringing appeals or cases against this refusal, and as a way of gathering evidence for their appeals, they sought access to the personal data held about them. And as we've already seen, the right to access your own personal data, the right is one of the individual rights. And the question was the extent of the information to which they were entitled. Now, there is guidance from the Article 29 Working Party, that is the group of European regulators who advise on European data protection law, on the extent of personal data. There's been some case law from the CJEU, although very little, but nevertheless, the exact parameters of what is or is not personal data in a particular case remains a difficult question of fact very often. And in this case, the applicants argued that the legal analysis of their circumstances, which had been conducted by the Ministry and was in their papers, should be regarded as information about them. And the Ministry of Immigration said no, that was not, that was legal analysis, and that was different from the information about their particular circumstances. And the court accepted that the legal analysis was not personal data. It restated that personal data is a broad concept. Information can be about professional life as well as private life, but it does not extend to legal analysis. And the example they gave of the distinction is to say, while your address will be personal data about you, an analysis as to what is your domicile for legal purposes will not be. Now, this is one of those decisions which seems to be a straightforward answer, but it does raise some interesting questions. What about a legal analysis of whether someone can be charged with a criminal offence? Would it be that the hard evidence would only be personal data, but the analysis based on that evidence would not be? And how, in a particular case, could you tease those two apart? Does it only apply to legal analyses or other kinds of analyses? As ever, it gives some help, but raises questions when we apply it to the facts. And with that, I'd like to just conclude with one final and factually very interesting case. And it's a case in which we haven't actually yet had judgment, but we have got an opinion for the Attorney General. And as you will know, before judgment in the court, there will be an opinion from the Attorney General, which may or may not be followed. In many cases, it is, but it's not. It's not a foregone conclusion. The Attorney General opinion was delivered in June 2013, and we've still not got the final decision. The case reference is C13112, and it's Google versus the Data Protection Authority for Spain. Now, in essence, in this case, an individual wanted the search engine Google Inc. to stop displaying information about him in its search returns. The information that was being displayed was lawfully published on a Spanish website, but the individual did not wish to see it being returned in searches. So the questions before the court are complex ones, and in summary, they cover whether the processing of personal data by a search engine, by the search engine of Google Inc., actually falls under EU law. Google Inc. is, of course, a US corporation. If so, whether Google Inc. should be regarded as a data controller for that data under EU data protection law, for the data which it returns on the search, not for the indexing. And finally, whether an individual actually has a legal right to require a search engine provider to block data that the individual does not want to see provided in response to a search. The Attorney General's opinion is long and detailed. I doubt I'm getting anywhere near doing it justice here, but overall, he considers that while Google Inc. does fall under EU law for these purposes, it cannot itself be regarded as a data controller for the data returned in the search results, and nor, under the current directive on data protection, does an individual have the right to block a search returned, block to prevent the index and delivery of search results relating to him. As I've said, the CJU may, of course, take a different view, but whatever the final judgment, it will give us some important guidance on a very central question under the current law, and some questions that are still being hotly debated as to what the law should be in the ongoing work on the draft regulation, on which Anita is going to take us through now.
Thanks, Rosemary. That brings me on to the first of my topics, which is to cover the new legislation coming from Europe. As many of you will know, the current legal data protection framework in Europe is undergoing change, and in January 2012 the Commission proposed a general data protection regulation as well as a directive for law enforcement authorities in the context of the processing of personal data that they undertake. The first draft proposed by the Commission contains some quite radical proposals, the most significant of which is the formulation of the legislation as a regulation as opposed to a directive, which we have now. A regulation would be directly applicable on each member state without the need for implementing legislation at a local level, which is unlike a directive, which requires implementation at a member state level and then leads to some of the consequences that Rosemary explained earlier, with the differences in implementation across member states when it comes to exemptions, for example. And we're going to see some of these, the same themes running throughout some of the cases that I speak about. We see differences in the approaches taken by data protection authorities when it comes to enforcement. In terms of the regulation, the progress on it over the last 2 years has been slow, and that's really down to a variety of reasons. The nature of the legislation as a regulation has meant that member states and MEPs in Parliament have focused a lot of attention on the detail of the proposals, which has taken time. And the European Parliament actually received over 3,000 amendments when they first considered the Commission's proposals, in total from the 5 committees which considered the Commission's proposal. That being said, the European Parliament in particular has been able to make some concrete progress, and in October 2013 we saw a vote passed in the European Parliament, and they produced what they called a compromise text. So this was basically their version of the Commission's proposal of the regulation, which had been agreed by all of the committees of the European Parliament. In contrast, the Council of Ministers has also been reviewing the proposals from the Commission. Unfortunately, they haven't reached a concrete decision as to what the text should look like, but they have made progress on chapters 1 to 9 of the Commission's proposals. Unfortunately, there are 1 or 2 key principles that still have a lot of disagreement and actually confusion surrounding them. One of those principles is called the one-stop shop principle, and it's also known as the main establishment principle. And this is the concept that's been introduced into the regulation that would allow one lead data protection authority to act as a point of contact for companies who have multiple establishments across the European Union. However, the practical aspects of that mechanism and the logistics and the interaction with national law is still something that needs to be worked out, and the Commission, the Council is working with the Commission's legal service on that issue in particular. So the data protection regulation was expected to be passed prior to the European parliamentary elections in May 2014. Unfortunately, it looks like this deadline won't be met, and 2015 is looking more likely as the date for the passage of that piece of legislation. One other development that needs to be taken into account is also the change in the members of the Commission, which will take place in November 2014. Finally, I'll just round up the legislative update with a word on the directive, which I mentioned in relation to the processing of personal data by law enforcement authorities. So that directive was introduced by the Commission at the same time as the regulation, but unfortunately most of the focus was on the draft data protection regulation, and the directive has lagged behind in terms of progress made on it. Again, we expect there to be a delay in the passage of that legislation, and 2015 seems like the likely date for that. Moving on from the legislative update, I just wanted to give a brief summary on one of the cross-border data transfer mechanisms that's come under fire recently. That's called the Safe Harbour Framework, and this allows companies who have self-certified to the Safe Harbour Framework to transfer personal data between the European Union and the United States freely. Since last summer, however, it's been the subject of a lot of criticism, and that's really intensified as a result of the recent allegations we've seen about the American government's surveillance of European citizens, amongst others. We've seen in the last couple of months some formal statements being made by the European institutions showing and demonstrating their criticism. In November 2013, the European Commission issued a statement which identified 13 recommendations that it was making to improve the effectiveness of the Safe Harbour framework. These 13 recommendations really focused on improving the transparency of the Safe Harbour framework in terms of how data is transferred, as well as ensuring that the monitoring of the Safe Harbour principles which companies sign up to is monitored effectively. The US Department of Commerce is the US authority that's responsible for the Safe Harbour framework, and they're now looking into these recommendations, and we hope to see some developments this year in 2014. In addition to the European Commission's criticisms, a leaked draft report was also made public. That was by the European Parliament, the Civil Liberties, Justice and Home Affairs Committee. That draft report actually went one step further than the European Commission's recommendations. It actually suggested and recommends suspension of the Safe Harbour framework until the loopholes within the framework can be remedied. So we're seeing a lot of criticism and development of the Safe Harbour framework. I think in contrast to that, we've then in the last few weeks seen the FTC, which is the US authority responsible for enforcement of the Safe Harbour framework. We've seen the FTC announce a settlement with 12 companies for allegedly falsely claiming to have complied with the Safe Harbour framework and associated financial penalties that have gone with that. So it definitely seems as that the direction of travel is one of improving the Safe Harbour framework as a transfer mechanism, and I think the Safe Harbour framework, as well as the new draft data protection legislation, will see some developments in the coming year for both of those. I'm just going to briefly look at some recent cases that we've seen at a member state level. Obviously, Rosemary's already covered the ones at a European level. The first one I'm going to cover is in relation to the Google privacy policy, and this relates to the enforcement by different data protection authorities across Europe and the approaches that they've taken. In March 2012, Google rolled out a new privacy policy. Prior to this, Google had a privacy policy, a separate privacy policy that covered each one of their products and services. And in March 2012, they rolled out an updated privacy policy which would govern the collection and use of personal data across their products and services. Now, this rollout of the new privacy policy garnered a lot of attention from data protection authorities. Out of the 27 member states at the time, 6 countries announced formal investigation action. These were the Netherlands, the UK, Italy, Germany, France and Spain. And the first of those 6, the first 4 of those 6, are still under investigation at those data protection authorities. However, in France and Spain, In the last 2 months, in December 2013, the Spanish Data Protection Authority issued a fine of €900,000 on Google for breach of Spanish data protection law. And in January 2014, the French Data Protection Authority, the CNIL, fined Google €150,000 for breach of French data protection law. And I think the approaches taken by the different data protection authorities in relation to Google's privacy policy just shows the nature and the kind of fragmented nature of the data protection requirements and standards we have across Europe. We've seen 2 data protection authorities taking enforcement action but separately, rather than a more unified, harmonised approach. In both those cases, in relation to Spain and France, Google are appealing the decision of the data protection authorities. We're now just going to spend a few minutes just looking at the courts and their interaction with data protection. The first case involves Facebook. This is a really interesting case because it looks at the application of member state law, of member state data protection law, where a company has multiple establishments across the European Union. The case relates to a requirement that the German Data Protection Authority made in relation to Facebook. It required Facebook to allow the use of pseudonyms as usernames. Facebook rejected this decision by the Data Protection Authority, and on the basis that German data protection law didn't apply to it, it said its main processing operations were in Ireland, and Irish data protection law was the applicable law. In April 2013, the Higher Administrative Court of Schleswig-Holstein issued 2 decisions and found in favour of Facebook. It agreed with Facebook and said that Irish data protection law applied. Interestingly, it said that the only operations that Facebook had in Germany was a German marketing and advertising business, which was incorporated as a separate legal entity, and they didn't think that that was a sufficient nexus to warrant the application of German data protection law in that case. Similarly, in a recent case in the UK involving Google, we've seen the UK High Court again look at the issue of jurisdiction and applicable law. This case relates to the setting of cookies, the alleged setting of cookies by Google on users' devices without their consent on Safari browsers. Google argued that the case should be heard in California because they were established in California. However, the claimants made their claim in the UK. The High Court in January 2014 disagreed with Google and indicated that the UK was the appropriate jurisdiction for the case to be heard, and so that case will be heard later on this year. That's all from the case law updates and the legislative updates. If you are keen to stay up to date with the draft regulation, you can find updates on our microsite at www.huntonregulationtracker.com. Thanks for joining us today.
Thank you very much.